All right, thanks so much for being with us here on Atlanta News First Plus. I'm Joy Limnacker, joined today by attorney Jamara Edwards-Shipp. Thank you so much for being with us.
Thank you for having me, always.
So we've got several legal stories that we want to talk to you about. First thing, I just want to let everyone know we are watching what's happening inside the courtroom regarding the 1145 lounge. And this is something that, we've obviously been following very closely because there's now proceedings about whether 1145 should actually remain open. We know that it's been the site of deadly violence earlier this year, and there was a temporary restraining order filed to essentially close it down on a temporary basis, but now there's a push to close it permanently, and that's what today's court hearing is all about. You and I have been talking about this before we went up on the live stream. What's your reaction? What do you think that the court is going to be looking at here today?
I think the court is going to be weighing the factors of whether or not this is going to be beneficial to the safety of the public, or is this going to be something that infringes upon the rights of an individual to have their business operated. And they're going to weigh those factors and determine whether or not it'll be in the best interest to go ahead and shut this club down. I think with all the evidence that points to there being multiple shootings, this deadly shooting that just happened this year, I think they're probably going to lean more into determining that, yeah, we should go ahead and shut this club down permanently.
Yeah, and of course we're going to be watching what happens with this hearing today and keeping close eyes on that. And we'll let everyone know if there is a ruling made, whether it means that the club will remain open or whether it's going to be forced to shut down as well. Another major story that we've been following, of course, is what's happening with the so-called Cop City, the Atlanta Public Safety Training Center, and the cases surrounding it as well. Well, now, in a new development, a judge in the so-called Cop City case is saying that Georgia prosecutors committed, quote, gross negligence with emails in the case. Essentially, they're being accused of mishandling confidential emails between a defense attorney and 3 Atlanta activists who are facing racketeering charges connected to violent protests against this planned police and fire training center. Obviously, that's what critics call Cop City. First of all, what is such a big deal here? I guess my question is, can you explain for our audience, what is attorney-client privilege, and why is it so important that privileged communications stay confidential?
Okay, so attorney-client privilege is whenever you hire an attorney, whatever you and that attorney talk about in regards to your case is considered privileged, is confidential, it's not supposed to be shared with anyone. It's just between you and the attorney. And what this judge has said is that prosecutors did gross negligence by allowing some of those communications, which were encompassed in the emails that were scanned as part of the investigation, to be given over to investigators. Now, she notices, she says gross negligence. She's not saying that it was, purely something that was done on purpose. It's just, hey, if you would have done as we told you by having an independent person take a look at these emails before you actually sent them over, then we wouldn't be in this predicament. And again, I think that just lends to the idea that attorney-client privilege is sacred. You shouldn't have people who are investigating you for a crime know exactly what you and your lawyer are talking about, which could even entail, hey, did you actually do the crime or anything of that nature?
Yeah, and I'm just kind of reading a little bit further on it, and the Assistant Attorney General, Hallie Scott Dixon, apparently told the judge it was extremely upsetting as a prosecutor to find out that this had happened. When we realized that it happened, with all candor, I was sick. Again, it's not that it was intentional, but still damaging nonetheless.
Correct. You're going against guys like Don Samuel, who is esteemed in his own right. He's actually written the book on evidence in Georgia. So with that being said, this is going against an attorney who knows about attorney-client privilege, who knows about evidence, who knows how things should be handled. And to find out that you committed such an egregious error by giving over these privileged communications to investigators, yeah, it would be sickening.
Yeah, absolutely. I want to ask you about another trial that we have been covering here, gavel to gavel, here on Atlanta News First Plus, and that, of course, is the massive YSL RICO trial involving Jeffrey Williams, a.k.a. Young Thug, and his co-defendants. So, again, there's a major push again by the defense for a mistrial. But it looks like they actually have new grounds. I mean, they had already motioned for a mistrial previously, and that's something that the new judge in this case, Paige Reese Whitaker, she denied that motion for mistrial earlier this week. But then now there's these revelations of another secret meeting. Remember what led to, for our viewers, I know you know this, but
Right.
Judge Ural Glanville being removed from the case was essentially an ex parte meeting that was held between the judge and the prosecution without the defense being present. And now there's revelations that, okay, there was a second one of those. So the question is really, was there so much bias and so much, I guess, wrongdoing, mismanagement, whatever term you want to use, that they should just start from scratch, that there should be a mistrial?
So this is the case of the never-ending YSL trial, and again, I think my professional opinion is that a lot of this case could have been settled, or even, you could have come to terms with some type of plea agreement if a reasonable plea agreement would have been offered to some of these defendants. In the Fulton County District Attorney's Office, trying to go for the gusto and kind of make a statement, they I guess I caution to say, overcharged a lot of defendants, and now we're at this point where the mismanagement, some of the, wrongdoing, as earlier stated, is now coming to light. You have a situation in which you are making comments about one of the attorneys and, their relationship with one of the defendants, making comments about that to the judge, and it just lends to this idea of the look of impropriety that many of our clients always complain about, especially the relationship between judges, prosecutors, and defendants. So again, I think it really lends into this idea that a mistrial should be granted because there is so much wrong going on with this case. And as you peel back the layers, I think it was one of the attorneys said, as you peel back, you start to see more rot, more rot, more rot. And at what point do you just say, hey, this is just wrong on so many levels, let's start over?
Yeah, I mean, the concern is we're 19 months into the case, so you start over. 19 months, I mean, that's a year and 7 months. You start over, then it's going to be years, like several more years until we get to the end of this trial. And so how effective of a trial is that going to be when you have, witnesses relocate, they're now out of state, their memories fade, all of these issues, people pass away. I mean, that's a whole other issue, right? So maybe is that why the judge has not granted the motion for the mistrial?
I can't really speak into the, mindfulness of the judge or what they may be thinking, but I think anybody who is on the outside looking in would look at this and say, yes, there is the idea of what is called sunken cost, or, when we get into economics terms, we start looking at what all has the taxpayer paid for over these 19 months, and to then say, hey, it was all, a wash, we got to start all over. I think maybe the powers that be are looking at this and saying, we don't want to have to start over to try and do, jury selection, to have to start over with our motions, to kind of just replay all of this all over again. Yeah, the powers that be are going to say, let's keep it moving, let's forge ahead.
Yeah, absolutely. Thank you so much for your insight on that. Before we let you go, what kinds of, whenever you come on, we always get questions. How can people reach you, and what kind of cases do you want to take?
Alrighty, so you can reach me on Instagram, JShip Law. You can reach me on Facebook, my real name, Jamara Ship. The Law Office of J. Edward Ship, jshiplaw.com. General practitioner. I take a look at pretty much anything, and we determine whether or not we can help you.
Yeah, absolutely. Well, thank you so much for joining us, Attorney Jamara Edward Ship. And for our viewers out there, if you want to get the latest on all these top stories, not only go to atlantanewsfirst.com, but also I really recommend downloading our free app. You can get updates sent right to your phone. Thanks for joining us.